what goes with what.
Yeah. I had that same question because of the use of DOC codes.
Right from the opening, we're dropped into a tense habeas corpus case. Richard Powell claims he's innocent and already wants his lawyer replaced. That's a bold move this early. Something clearly isn't working behind the scenes. Stay with this one. Hit subscribe now, because this courtroom clash is just getting started.
District Court of Butler County, Kansas. Case entitled Richard Powell versus Jeff Zamuda, and it is case number 2024 CV 234. Elizabeth Fowler appears on behalf of the Kansas Department of Corrections. Mark Sievert appears as court-appointed counsel. Richard Powell appears from the El Dorado Correctional Facility. This matter comes before the court at this time for further proceedings in regard to a petition for habeas corpus relief that was previously filed by Mr. Powell. Mr. Sievert was subsequently appointed by this court to represent Mr. Powell, but I see in this file that you filed a document called judicial notice, also a motion to replace counsel. Are you dissatisfied with your attorney's services in the short time he's been your lawyer?
Yes, sir. When I talked to him just a minute ago, he acted like the petition wasn't legible and everything. You know, I'd have met all the filing fees, and he acted like he didn't understand what was going on with the case, and everything is in the petition. He wrote me a letter asking me what issues to file. I mean, he said he present in front of the court. And I told him, hey, man, all the issues until this is dismissed, because I don't think he's capable of shedding light on my innocence, you know. And from how he acting, I mean, this ain't hard, because, you know, I'm innocent. This guy went in to 2 different cells, and, you know, and then they didn't even let me call him as a witness. Then they tried to say that I didn't submit the witness form in time, which I did, but that wasn't no problem when I went to the hearing at the facility, when I went in front of the hearing officer. And all of a sudden, when I'm appealing it, he bringing up, I guess that's a tactic they use or something. I ain't for sure, Your Honor, but hey, I put in that witness form. They said I couldn't call this guy because he was a victim and was intimidated, and I was in segregation when I went to the hearing and everything, Your Honor. And, you know, they moved the guy in the cell with me, and he had got in some trouble. I had a private industry job. I lost everything just because this whoever wrote that DR thought that I did something to him. And they wrote 2 people up for the same infraction. You know, me and another dude. They said he done it, and they said I done it. I mean, I ain't did nothing to nobody.
Okay, I suppose the threshold issue that the court needs to resolve today is whether Mr. Sievert's going to be relieved as your attorney. Mr. Powell, Mark Sievert is a very experienced attorney, and that's why he was appointed. I need to determine before I relieve him from the court's order appointing him that you have a justifiable dissatisfaction with him. Again, I would tend to agree, Mr. Powell, that your petition, though somewhat wordy, I think does set forth generally the issues that you're wanting this court to consider. Essentially, you're just attacking your conviction because you believe you didn't do it. Is that a fair statement?
Yes, sir.
Okay.
Because I didn't do it.
Okay.
And Your Honor, if you look at the video, right, you'll see that this guy, when they accused me of doing it, right, they said I came out the cell and another guy that wasn't even in our cell come out the cell. They wrote us both up for the same thing, the other guy. And then this guy goes into another cell downstairs, and then he come back in the cell, and all 4 of us cellmates is in this cell together. He leaves, go back downstairs talked to somebody else, and then he heads out the cell house. I guess he went to the clinic or somewhere. Then they said, I did it.
Mm-hmm.
That
Okay.
don't make no sense.
All right. I'm not really wanting to put you in a position where you're just solely representing yourself here, Mr. Powell. Mr. Siebert, did you have any statement that you wish to make here?
Well, Your Honor, I think really what Mr. Powell is perhaps wanting is to represent himself. I have asked him a couple of times to kind of clarify, whether it's a self-defense claim or whether it's a I didn't do it, period claim. And I think I've got that cleared up now that it's, didn't do it, period. I was a little bit confused, I guess, from reading this, what actual sanction he received. And I'm not trying to pick on his handwriting or even his English. There were a couple of references in here and I wasn't quite sure what goes with what.
Yeah. I had that same question because of the use of DOC codes as sanctions. And if you, I had the same question. I can attempt to interpret it. Ms. Fowler's probably best. I'm just looking at the hearing record. And at the bottom of the hearing record, sanctions are listed, but they're all in abbreviation and codes. Ms. Fowler, if you could just read the sanctions with your knowledge of what it all means, we might be able to figure this out, but I want you to say affirmatively what were the sanctions that he received.
Well, Your Honor, as I understood with the exhibit attached, and I think I mentioned it in my response, 15 days of disciplinary segregation, 30 days of restriction from privileges, and fined $10. Now, Your Honor, with respect to that, that was the original. He did file his appeal to the Secretary of Corrections, who did reverse that $10 fine.
Yes. 45 PRCS.
Around this point, the focus shifts to the actual sanctions, segregation time, privilege restrictions, and even a fine that got reversed. These details matter because habeas claims hinge on rights being affected. If there's no real loss, the case weakens. So what do you think? Are these penalties serious enough legally?
I mean, the 15 days segregation. Okay, I see that. And again, I'm looking at the page 2 of Exhibit 4, which is literally the hearing record. And then the sanctions, which were probably announced at the time, 15 days segregation. I see the $10 fine. And then it says 45 PR P/R/C/S.
And Your Honor, that is, I see now that is my mistake. It should have been 45 days of restriction privileges.
Okay.
And I put that incorrectly into my, so for the record, I would ask that the court note that it was 45 days and I mistakenly wrote 30.
Okay, is there an additional penalty associated with the term CSIMP?
Your Honor, it's just consecutive and imposed.
Okay.
And I appreciate that clarification. There was also the concern that part of the sanction was he lost his, that his industry job was taken from him and that he was moved to a different facility.
Right.
And is that
and I stayed in segregation for months until they moved me.
Okay.
And the other guy that they wrote for the same DR, he went home.
All right. Okay. Okay. Regarding the question of representation, before we get into this any further, I just wanted to make sure I had a handle on what sanctions were imposed. Ms. Fowler has helped to clarify that. Thank you.
Thank you.
All right. So do you want to represent yourself here, Mr. Powell, or You're wanting to fire Mr. Sievert and get a new lawyer? What?
Yeah, I'd rather do that because, you know, he said my handwriting ain't right where he can understand petition. You know, this is, I mean, this is not hard. I mean, I paid all my filing fees and, you know, everything. I mean, man, I had to fight it, Your Honor, because I didn't do it. You know what I mean? Now, if I would have did it, I wouldn't have filed nothing. I wouldn't waste the court's time, you know. But I do want somebody that's gonna represent me that, go ahead and get it dismissed, you know, because they've been stringing along for too long. I
Okay.
wanted my record. If I didn't want it off my record, I wouldn't even pay the filing fee. I would have just said forget it. But you got to stand up for something if you innocent. You know, I need an attorney that's gonna shed some light on my innocence.
Mhm. Well, the court certainly sees as an issue in this case, which we're not, I think, going to fully get into today. The court has to find that there was some evidence to support the conviction. Just noting, Mr. Powell, that there's different standards of proof in Kansas. The highest standard is the criminal standard, beyond a reasonable doubt. Then there's clear and convincing, preponderance of the evidence, and then there's the one that applies to disciplinary proceedings, which is some evidence, probably the lowest standard of the four. But the court still would have to make a finding that there was some evidence to support the conviction. But again, that probably is going to have to be determined at another day.
Now things take a sharp turn. The state argues Powell hasn't even lost a protected liberty or property interest. That's huge. If true, his entire case could collapse without ever reaching the facts. Meanwhile, Powell is still focused on proving innocence. Is he fighting the wrong legal battle here? This tension is critical.
If you're wanting a new attorney appointed, Mr. Powell, I can accommodate that request.
Yeah, because I want to subpoena, you know, the guy that they said got injured.
Okay. All right. Understand, Mr. Powell, that we're not going to retry the case at the district court level. Our job here is to look at what was done at the prison level and determine whether that disciplinary conviction should be upheld or not, based on what happened down there.
Right.
Okay. So just so you understand that. I'm sure Ms. Fowler will have an explanation as to why the hearing officer didn't allow the alleged victim to testify.
Well, Your Honor, I guess with respect to threshold issues, and I understand if you're appointing new counsel for Mr. Powell, but I guess my threshold argument would be that there's no liberty or property at stake here, and we don't even get to the analysis of whether there was some evidence. Mr. Powell has failed to present that he was deprived of any liberty or property interest at this point. And if the court wishes to take that up at a later date when Mr. Powell has new counsel, I appreciate that.
Then that's what the court will do. Because I don't want to make a determination on the merits of his petition in any way without an attorney on board. Mr. Sievert, thank you for your service to the court on this case. Mr. Powell apparently wishes for new counsel to be appointed, and the court will endeavor to find an attorney to represent him in the case, and we'll reset a hearing. I want to go ahead and do that now. We get into a very difficult time frame on the court's calendar. Ms. Fowler, I could possibly look at doing this the morning of May 1st. Mandy, my administrative assistant, will let me know if somehow there's some other conflict, but I think 10 o'clock a.m. on Friday, May 1.
I could do that, Your Honor.
All right. Well, this hearing will be reset to Friday, May 1st. The court will find new counsel to represent the inmate in this case. We will issue a new order for Zoom hearing to the facility so that he is available for us Friday, May 1, 10 o'clock a.m. for further proceedings in the case. At that time, Ms. Fowler, I'll address your concerns about the threshold issue that you raised.
Thank you.
All right. Mr. Powell, you have any questions about what we've done here today?
No, I ain't got many. I just want a fair hearing and somebody that's gonna represent me, that's gonna argue my due process, because they didn't let me call the guy, this victim guy. They didn't let me call him, and I just want all the evidence to be in front of the court. Somebody that's gonna help me shed some light on my innocence. That's it, Judge Rick.
All right. May 1, 10 o'clock a.m. for further proceedings in the case. Mr. Sievert's relieved his counsel and will appoint new counsel.
Appreciate y'all. God bless.
Thank you,
If there's
Judge.
nothing further at this time, the Richard Powell matter will be in recess at this time, and this meeting may be ended for all. Have a good
In the end, the judge doesn't rule on guilt or innocence, but makes a key decision. Powell gets a new attorney, and the case is reset. That keeps his claims alive, but nothing is decided yet. The real fight is still ahead. Like, comment, and subscribe for more intense courtroom breakdowns.